Hi, everybody. We're back, La Gringa y La Chapina, and we are doing our best to improve the podcast so that you guys will enjoy us more as we talk about immigration issues and explain immigration processes. My name is Hadley Bajramovic. I am a senior immigration attorney and CEO of Immigration Law Offices of Hadley Bajramovic in Riverside, California. And with me is La Chapina.
Hello, Zayra Ivette Padilla, La Chapina. It's a pleasure speaking to you again. And I'm the senior manager, interpreter, and 10 more titles. I don't know anymore. I've been with Hadley for more than 14 years. So it's always a pleasure to engage and talk to you guys about what's going on. We want to discuss today consulate processing. We know that we constantly get these type of case in our consultations, and there's still a lot of misinformation out there in the community. So we really want to focus today on talking about consulate processing. What is it? Why do I need to go out? How long do I stay? Can I ask for my waiver inside the U.S., my pardon, mi perdón?
Yeah.
Things like that. So we want to discuss that information today. So we just had a consultation today, and the customer was saying how she was told that she was gonna have to leave the country and stay out for at least 2 months to 2 years. And we were like, who told you this? Was it really an attorney? Because that's very sad if it was an actual attorney or was actually a notario who practiced the law illegally. And she's like, no, it was an attorney, but yeah. So we want to talk about that.
And I heard, because I can understand some things, I heard her say, unless there was a change in the law. Yeah. Well, yeah, there was, but that was in 2013. But, and we haven't been talking about consular processing in depth because of the Biden parole in place.
Yeah.
Biden parole in place, is going to help people not to go out. People who get Biden parole in place, which is just on pause until October, will not have to do consular processing. But when we talk about consular processing right now, we're talking about family-based consular processing. There are different types of family petitions that are eligible for consular processing. They're petitions from U.S. citizen spouses or green card holding spouses to, the partner that needs to be petitioned. A parent can petition a child, and a child can petition a parent, and a U.S. citizen brother or sister can petition their siblings. Zayra, we pointed out who has standing to petition.
Yes.
So we'll talk about this today in the context of a U.S. citizen's spouse petitioning. But please know when you're listening to us that there are other relationships that can do consular processing. Anybody who has standing to file an I-130 family petition for a green card can use consular processing. And the reason that it's a very common process for us in Riverside is because I think we have 150,000 undocumented people. I mean, that's directionally correct. Let's just say there are a lot. So when an individual is in the U.S. without status, they have to leave the U.S. where they're no longer undocumented and go to their country to attend this interview, because you can't adjust inside the U.S. if you're undocumented unless there's an exception that applies. And the most common exception is if somebody entered the country legally and has an immediate relative petitioner. And the other exception is 245I, which ended on April 30th, 2001. We're not going to go into those processes now. We're more than happy to go into each of them in detail. We want to focus today on why you have to go through consular processing and what the real wait times are. So Zayra, why don't you talk about the I-130 for a U.S. citizen spouse? How long do you have to wait? What are the requirements for evidence? That kind of thing.
Yes. So if your spouse is petitioning you, it's a U.S. citizen spouse. We're going to focus on being a U.S. citizen spouse. We just need just civil documents, which means your birth certificate, your marriage certificate, proof that your spouse is a U.S. citizen, and then and bona fides of the marriage, which means just proof that you guys are a valid marriage, that you guys are not getting married because you want a status or anything like that. So it's like family photos, just graduations, baptisms, all those events that we do as a family. Those kind of, like around 15 photos of that. That process is taking 14 months. So it's taking a little bit. So, a lot of people have still that idea of that back in the day, oh, if you're married to a US citizen, you're going to get approved like in 6 months, in 3 months.
Yeah.
We used to have that, 14 years ago, it was, great, really fast, but now it's taking 14 months. Here's the processing time of an I-130 through a U.S. citizen spouse is 14 months. So you have to obviously wait those 14 months in order for us to even submit an inquiry and see why it's taking more than 14 months. But before then, we cannot do anything. We just file the best case possible, like we always do, and then wait until USCIS decides on the case, which 99% of the time it's just the approval. We usually never get request for evidence, additional information that they want. We don't get that. We usually get, approval notices. Then the next step will be for us to start preparing for the waiver for the I-601.
So Zayra, I wanted to tell you, I don't know, because you've been like not doing so much of the casework, because your position is different and elevated from doing those types of things. Everybody in my office is now filing I-130 petitions online. I think it's amazing the differences in the service and the information that you get filing online. And then the USCIS makes it a cheaper process. Meaning the filing fee for filing the I-130 is lower if you file online. So they're encouraging you to use the online systems.
Yes.
And how many times does an average client call to ask for a case status update?
Yeah, many times. Even though
Many times
we explain to them how long it's gonna take, that we cannot do anything. And now with the online filing, like Hadley explained, now we can say like, look, this is your information. You can log in, you can get text updates actually, and email updates. So we have that advantage of filing online nowadays, that we can do that before you just be everything on paper. So, that's a big advantage now for people to be, more trustworthy of the process and not, thinking like, oh, we're just taking our sweet time. We're the ones that don't move the things around or do whatever. Because a lot of people have this idea in America that, you pay, you get whatever you want kind of idea.
Well, so you said make the monkey dance. That's what you told me.
So some of them still have that idea that you have to have connections, and you might have, these kind of ways to get ahead of the line kind of thing. No, it doesn't work that way. So we just have to wait until USCIS processes the case, and then we can move forward with the next step.
So I like the fact that the applicant can take control of the information with that online process. So you're about ready to get into the provisional waiver. So this is the consultation Zayra and I had today, where the person that we were talking to believed that she would have to, she believed that she was going to go to Honduras and then file the waiver once she was in Honduras. That's used to be the order of operations prior to 2013. So the applicant would go to their home country, attend an interview, and then the officer would deny the applicant for unlawful presence and admissibility or bar. So the officer would deny the average person because they were in the U.S. illegally. So then the officer would give the applicant a piece of paper that we would need to file the waiver. So the waiver could not be submitted without that Department of State piece of paper. Well, President Obama was trying to figure out why people weren't moving forward. And I remember this is around the time I was first practicing. Nobody wanted to move forward because it was so dangerous. I mean, the consulate of Mexico was in the city of Juarez, and they were making movies back then where they had headless bodies hanging off the bridges in Juarez, and people were getting kidnapped. And so nobody wanted to go to their interviews, so they were just getting to that point and then canceling them. So yes. President Obama said, okay, we're going to change the order of operations, and we're going to allow people who have the qualifying relatives for a waiver to file the waiver inside the U.S. and get the approvals inside the U.S. And during that time, they're going to be considered to be lawfully in the U.S. So it was a game changer for us. It took us a while to really wrap our heads around it, too. I remember we had a big chart on the wall of all of our I-601 cases. Mm-hmm. And so the USCIS took a couple of years to get their standards clear, too. I remember some members of our office went to a Las Vegas workshop where the USCIS said, okay, this is what we want. But it all happened in 2013. It started in 2013. And what the USCIS is asking for is proof that the applicant should be allowed to waive their unlawful presence bar, which is normally a 10-year bar, because the spouse, the U.S. citizen's spouse, cannot move to that person's home country. Like, if I'm the applicant, that means I'm from Mexico. My U.S. citizen husband cannot be expected to move with me to Mexico to keep our family together. So the waiver proves that it would cause extreme and unusual hardship on the U.S. citizen spouse to move to the home country to keep the family together. And so the USCIS has really helped us to understand what they're looking for, what type of equity just means, what they want to prove the hardship. Like sometimes we do psychotherapy. We send people to therapy to show that the U.S. citizen,
And one of the things that we often heard, Hadley, was that, people were going to notarios and getting those famous letters, like 14, 20 letters that they will get from like family members, church, things like that. And then they will also ask them to go to a psych evaluation, which it was pretty costly. And so they would say, okay, give me 20 letters plus the psych evaluation, and we can submit this, they call it la carta del perdón, which literally means like the waiver letter, which to them it was going to pretty much sound like, oh, it's just this 2-page letter that we're going to send to USCIS. So we have so many people that would be like, oh, you mean I don't need 20 letters from whoever? We're like, yes, we do want to show you that you're a good citizen, that you're volunteered and do these things, but it's not like a mandatory of like 20 letters from random people that really don't know you.
No, the burden of proof is that we must show that it will cause extreme and unusual hardship to the spouse. Exactly. If they're not allowed to be in the U.S. I mean, good moral character is great, but it's not the burden of proof.
And that's why, that's why all these people will come to us after they went to notarios, and a lot of them were already denied because they would just pretty much complete the form, the application, submit those 20 letters and the psych evaluation, and that was it. No brief, no explanation, nothing.
That all said, now we've got the I-601A waiver like an ARC form. We know what the USCIS is looking for. We can't guarantee anything, and I don't like it when lawyers guarantee results. but of course it's not only that I don't like it, it's not ethical. But, we know what they're looking for to prove that a spouse will suffer extremely unusual hardship. They're looking for deep family ties in the community. Like if your U.S. citizen spouse, all their family members are in the U.S., like grandma, great grandma, cousins, uncles, nieces, nephews, even children. If the spouse has a career in the U.S., like if a spouse went to a 4-year college or a 2-year college or even kind of a certification kind of a program, and then has a job which will allow that U.S. citizen to be promoted and to advance in a career, that is a hardship. If the U.S. citizen spouse has children in college, and they're paying for the college, that's considered an extremely unusual hardship. These are the situations that the USCIS considers when granting a waiver. They're not that interested in what your 20 neighbors think about your moral character. I'm just explaining now what they're looking for. And then once we've filed a brief, not a letter, but a legal brief that explains under the law why the applicant meets the requirements of the waiver and should be approved. The problem is now that the waiver process is 42 months for the approvals. One of the problems with the waiver is that the individual applicant, the U.S. citizen spouses are always eligible for the waiver. But parents of U.S. citizen children are not always eligible for a waiver. We really want everybody to understand the waiver process. We have a lot of parents that we have to tell them, you can file the I-130, your child can petition you, and then it will be approved, but you don't qualify for the waiver. And because of that, we can't move forward. And the reason is
because in order for you to ask for that waiver, for that unlawful presence waiver, you have to have a qualifying relative, which can only be a spouse or parents who are U.S. citizens or green card holders. So it's unfortunately, we get so many parents that come to our office and say, my child is finally 21. Can they petition me? We're like, yes, they can petition you. The petition is going to get approved, but because you enter without inspection, you need this unlawful waiver, unlawful presence waiver. And that's when they get obviously their hopes down because it's rare when we actually have somebody who's like, yes, my mom is an LPR, my father is an LPR. Then we're like, yes, we can actually move forward. Your son can petition you. The petition is going to get approved. And then the waiver is going to be on the behalf of your parent. We do get them sometimes, which we're so happy, but most of them are like, no, you can't move forward because unless you go to your home country for 10 years to waive those 10 years of unlawful presence that you have. And I think we only have a couple in 14 years of experience that I have and 20 years of Hadley's that we actually have people who are like, okay, I'm willing to go back home and wait there for 10 years. I think I only have a couple of ladies that did that. Other than that, they're like, no, that's not a choice for us. We cannot go back home and stay there for 10 years. And we're like, then you have to keep waiting and hopefully something will come up and you're going to be able to, have something else available for you other than, going out to your country and stay there for 10 years. And the other thing, how I want to mention again is that you're able to ask for the waiver inside the U.S. since 2013, which Obama announced. So that's very important for you to know because, like I said, we still have people that come to us and say, oh, an attorney, quote unquote. And I mean, why are you practicing immigration law if you don't know these things? It's been happening for more than 11 years.
Immigration law is hard, though. I think that a lot of people agree it's the most difficult law. It's very convoluted, very opaque, hard to figure out.
So, a good thing the lady was like, that doesn't sound right. The husband said, no, I mean, we should seek another advice. So they're like, we were able to find your number and contacted you. And now you're telling me that I'm actually able to move forward and stay in the country until my waiver gets approved, which we explained that it's going to be a while, but hopefully the parole in place is gonna it's gonna take off and it's gonna move forward, and then we're gonna clear the way for a lot of people that, and that means that those like for example the lady that spoke to us today, her process is gonna be expedited because of all the applicants that no longer need to exit the country anymore. So that's a good thing. I explained that to her. So
our theory there, just to reiterate what you just said, right now the waiver is 42 months processing time, but because of Biden's parole in place, a lot of people are going to pull out of the waiver process. So we think it's going to go faster. When we started, it was 6 months. You remember, Zara, in 2013?
Yeah, we were getting approvals in 4, and it was just like amazing. We're like, one of our first, which happens to be that the lady was from Honduras too. Her husband was Mexican. Doris, I hope she hears us on time. Hers was like, 4 months later that her husband's case was approved. So it's been a while since then, though.
Yeah, but it does happen. The approvals do happen. We've been every week, probably for about the past 6 months, we've had somebody go down to Juarez or El Salvador, and everybody's getting approved. But before you leave, we have to do something called National Visa Center clearance. So that once the waiver is approved, the waiver is filed with the USCIS, which is part of the Department of Homeland Security. Once the waiver is approved, the case is moved back to the Department of State for consular processing. And this is where we get into the issues of the affidavit of support, the financial sponsorship. So we have to show that the petitioner, who is also the sponsor, has sufficient income to prevent the applicant from becoming a burden on the state. And there's some very clear guidelines. We use the Health and Human Services poverty guidelines for the year. And like, for example, this is not exactly right, but if you have a household of 2, the sponsor must make $25,500 a year. And we use the prior year income tax returns. So we'll look at 2023 income taxes and submit those to the Department of State. If the petitioner sponsor doesn't have sufficient income, we can pull in joint sponsors.
Yes.
And we do that a lot. It's probably more common that we have joint sponsors.
Yeah, it's a common practice that we have. Like most of people do not comply with the income required. And a lot of people think because of that, they cannot move forward with the case, which is not true. You're still able to move forward with your case, even if your petitioner does not qualify to be the only sponsor. You can have your family members, neighbor, co-worker, whoever's willing to give us proof of status and their income tax returns, signatures, personal information. We're able to do that.
Yeah, the Department of State and the USCIS just require a joint sponsor must be a green card holder or a citizen.
Yes.
But everybody has somebody, a tia, or tio, or mom, or dad, brother, sister, children that have status. And sometimes it's community members. I've seen pastors petition or sponsor people. I've seen, friends. We've had to explain the duties a lot of times to joint sponsors. It's not burdensome at all. It's just showing your, like you said, proof of status and income documents.
Yeah, and I think that's the beauty about the immigrant community, how, you support each other. There's a lot of, clients that come and say, I've been waiting all this time. I have a lot of people who told me, if you need me to sign for you, I'll be willing to do it. So I think that's the beauty about, the immigrant community, that it understands our struggles. And, when you are able to help or willing to help. So I think that's great that, I mean, one time we had one person that actually, if I can remember, it was just one person that she just couldn't find anybody. But that's like one in like thousands, so.
But we must have found some solution, because we've never had a case fail over this. Never.
No, that's why I was like,
Yeah, there's some weird situations where we have to
but I didn't want to go into details.
But anyway, once the documents are qualified by the National Visa Center, then we're allowed to move forward with scheduling the appointment in the consulate. And to do that, we complete the DS-260, which is a form that is comprehensive. It asks for every school, every address, every employee. Your entire life is in a form with all your family members. We submit that form, and then we wait for the consulate to schedule an interview. We're expecting those wait times to change too, because of the Biden parole in place. We're waiting about a year for an appointment in Juarez. Honduras and San Salvador are much faster. Guatemala City much faster, more like 3 months.
Yeah, like a month.
Yeah.
3 months is really quick.
But what we've been also doing is comprehensive background checks to make sure that we know if there are any problems on the record, that the officer will have that information at the interview, like multiple entries, big problem because of a permanent bar. If an individual has an illegal re-entry and it's on the record, or by verbally providing that information, sometimes officers can tell by children when they're born, or expedited removals. That's a we can't move forward moment. If somebody has a permanent bar for illegal reentries or expedited removals and they came back after the removal.
I want to bring something out regarding that, Hadley, how important it is to seek professional help, because we heard so many stories over the years that, children, because they think they're able to complete forms, they do it, and they actually ended up deporting their own parents. Self-deport.
Because they don't know the devil in the details.
Yes. Yeah. So recently I talked to this lady who left after 30 plus years in the US to Mexico to her interview, and was obviously denied. And it was her child who completed everything and scheduled the interview in Juarez, and she left. And now she's stuck in Mexico. And I was just devastated. If you would have called us, we have a saying in Spanish that el hubiera no existe, like the should have, would have doesn't exist. Because once you do it, you're done. It's not that simple.
They went to an attorney and the attorney misadvised them.
Exactly.
So, also should do your due diligence and learn about the attorney. They got the papers from my friend, so we thought they were okay. You have to seek an immigration attorney who's been in immigration law for 5 years minimum. I mean, we've been doing this for 15 years. We have more than 7,500 cases, and we fought hard to learn all of these rules, these caveats, these issues to issue spot. And an attorney that doesn't do this as a regular everyday thing can't do that.
Exactly. We can Google stuff, but at least try to get information. Try to do your own research. Call. Everybody has an attorney, like we say, in their home.
And their family at their dinner table. Yeah.
Yes. So please, because I was just devastated about this lady who spent pretty much most of her life in the US and left, was denied, and now she's stuck in Mexico for like 10 years, which obviously that's not what she was expecting. And everything was done by her own child. And I understand he wanted to help, but then you're not an attorney. You don't know how complicated these things are. So please seek advice. Like Hadley said, look for attorneys that have experience, because these cases are very complicated. Immigration law is super complicated. It changes. You have to really watch all the details. And like we said, Hadley and I have been working for more than 14 years together. We talked to thousands of people for all this time in the community, not just in our office, but out in the community. So, we really look. I mean, if we don't know, we do our own research too, because it's not like we know
Yeah.
everything either. Everything changes, the details matter. You know what? I need to get back to you because I really need to study this. I need to ask my colleagues, my employee who's an expert on these kind of things. So it's not just like we know it all. It's just that we take the time to understand each case. And if we need to figure something else, we will. But we're just not going to be like, oh no, you can do it and go ahead and this is how much it is.
And then, like you mentioned that things change. Like one of the things that changed recently in Mexico, this was always happening in Guatemala with the consulate interviews, but they're now asking people specific questions about their children. So now we screen to see where your children are, because if your children were born in your home country and are now in the US, that's a red flag. The red flag is child smuggling. So if a mother brings her child with her, like in, let's say, the year 2000, when she enters the US for the first and only time, but she came in with a child, then they're being denied at the consulate. They've always been denying them in Guatemala City.
Yes.
And now they're doing it in Juarez. And, now the waiver for unlawful presence that they waited for 4 or 5 years is invalid. Now they have to file a waiver again for child smuggling. Yesterday we had a gentleman go down who had 4 DUIs. And we were really worried about that one because, DUIs are problematic. The Mothers Against Drunk Drivers have really pushed for that people who have multiple DUIs not be allowed to naturalize and things like that. And I mean, it's valid. It really is.
Mm-hmm.
But this happened with this person more than 20 years ago. And he went to the medical exam, and because of the 4 DUIs, he was sent to a therapist. But because we've been doing this for so long, we were able to prepare him for that happening and explain to him what they're looking for. We don't tell anybody what to say, but we have just prepare them for it. The same for marijuana. We had another client, because they lived in California. He smoked marijuana because he was very nervous about going to the interview, and went to Juarez for the interview and was tested positive for marijuana. It caused a lot of problems. He did eventually come in, but the problem is that marijuana is legal in California, but not federally. It's not a legal substance yet. So we had to be careful about that. We had to be careful about tattoos. We had a client who had a tattoo of the Aztec calendar, I think it's not somewhere visible on his body, but the Aztec calendar can be associated with certain gangs, and we had to do research on that and figure out, because if an officer has a reason to believe that the applicant is associated with gang or gang activity, that's another ground for a denial. So there are just a lot of things that we have to screen for, to prepare for, to go to these interviews. But after the interview, once they're approved, how long does it take, Zayra? When they say granted, we're giving you.
I mean, we have heard as fast as the next day that they get their passports. And now they don't actually give you a package with like your medical or whatever thing. It's just your passport and you just come and that's it. Now they don't even send you that.
But there's that fee.
Oh yeah, you pay.
What about that fee?
Yeah, you pay $235 before we always suggest for you to do it before you enter the country, that are not obviously represented by an experienced attorney, or they mainly they're actually going through a notario. They don't pay, they just come here. But many times we don't want to put you in any difficult situation. So that's why we always pay the fee, the $235, which is pay online. And then we give you the receipt. They print it out and bring it with them. So if they actually ask for the immigrant visa fee, you just show it to the receipt and you're done. You're inspected.
That's like when they're coming through inspection when they come back, right?
Yes. And then 90 days later, that's how long they state, USCIS state how long it's gonna take for you to get your green card in the mail.
Okay. And they won't release it until you pay. Yeah. So you have to pay the fee and enter.
Yes. And then like a week, 2 weeks later, you also get your Social Security card automatically comes to your house, because on the DS-260, that's one thing in the DS-260 that they actually ask you if you give permission to the Social Security Administration to send you the Social Security card. So you actually receive it right away instead of you going to the Social Security office and requesting your Social Security card.
Wow, we really covered everything. So that, folks, is the I-130 provisional waiver, embassy consular processing, consultation that we do, for our potential clients here on the podcast, so that, if you watch this, if you're considering doing a petition through a family member that's going to require consular processing, everything you need to know, we just told you.
Yes.
But still, you want to come to us.
Yes.
Come to us.
Schedule a free consultation with us. We'll be more than happy to explain everything to you on details and specifically that applies to your case. We do this every day, and we're more than happy to
all day long.
To explain all this process to everyone that is seeking information, reliable information. Because like I said, we have so much experience on this process that you need somebody who has experience, minimum 5 years. And so that's why we do this, and we do it every day, and we can tell you 100 million stories about all the things that we have experienced. And
Zayra, well, I'm going to just say goodbye to everybody. Thank you for joining us. We hope that you enjoyed learning about I-130, a petition for a family member, the provisional waiver I-601A for unlawful presence, National Visa Center processing, and the consular interview. And we will be back next time with lots of useful immigration information. Bye, everybody.
Thank you.